This recording is designed to assist you in walking through a pretty complicated topic, one called centrality of federal issues in federal arising under claims, or essentiality of a federal issue in a federal arising under claim. A couple points. First of all, what I want you to do with this is listen to the discussion of the cases that this webcast goes over. You can take notes on the worksheet that I've posted for this, but we are going to be covering this in class as well. The reason I wanted to provide a little bit more context for you in this video is that the casebook you have really truncates a lot of these initial decisions that Grable is really based upon. You'll see references to all of these cases in the page or two that occur before Grable in your book. They're printed there, but it's really missing a lot of the discussion. And so I want you to have some context to this, because Grable is not written in a vacuum. The Supreme Court, in the decision that we're going to discuss mostly in class, Grable, the most recent of the Supreme Court discussions of this issue, is really written with this historical context in mind. They're trying to resolve and make more clear prior decisions that the Supreme Court has rendered on this, and Grable doesn't really, I think, tie a neat bow around this, so it's very important to understand these prior decisions. It gives it meaning and context. So what I want you to do really is just listen and take notes on this. All you're going to be asked to do at the end of the video is just sign to Twen and sign a statement that verifies you watched it, but there's no quiz and there's no actual answers that you need to submit for your worksheet. Alright, with that being said, let's talk about the centrality of a federal issue in a claim. First things first is you need to understand what we're really talking about. For most claims filed in federal court under 1331, this is never going to be an issue. Most time you have a 1331 claim created because you've got an explicit federal cause of action stated in federal law. So if you look at the federal statute, it would provide you an ability to bring a claim. And we're going to look at some of those in class together, so you'll see what I mean by language in a federal statute providing you a cause of action. That's most cases that fit 1331. So as long as you meet the Motley well-pleaded complaint rule, you've pretty much finished everything you need for 1331. This issue, centrality or essentiality of a federal issue in a claim, only comes up if you've got a state cause of action that you're trying to assert has some sort of federal issue in it, such that it gives you a rising under jurisdiction. So you're really looking for state claims where you're basing jurisdiction in the court on 1331 arising under. If you don't have a state claim in which you're trying to claim 1331, then you're never going to address this. Okay, so that's the issue. Can the state create a cause of action, a private right of action, like negligence or breach of contract? Can those state claims ever create a federal question and give us 1331 federal question jurisdiction when a federal law is somehow involved in resolving that state claim? Well, there's a lot of dispute in discussions by the Supreme Court. We start with the first one, which is called American Well Works. Now, this is a case about a plaintiff who is producing a pump. The defendant in this case started accusing the plaintiff of infringing on a patent it had on a similar pump. Said, look, you're infringing on my patent on my pump. Plaintiff claims, nope, I actually have a patent on this pump. I'm not infringing on your pump patent. And so plaintiff brings a claim called trade libel. This is a state-created common law tort claim. And what it basically means is, you're saying you're slandering me because you're accusing me of infringing on your patent or in some way affecting your trade or your business. Okay. Plaintiff argues that it has a federal question in this state-created common law tort, and to understand this, let's unpack its argument. So plaintiff says, look, the act of libel that defendant is doing here is accusing me, the plaintiff, of infringing on the pump patent. That's what's the slanderous comment. So to prove that this is libel, we're going to have to show that the statement is false. In other words, we're going to have to show or resolve, is the plaintiff really infringing on the defendant's patent? Because if plaintiff is really infringing on the defendant's patent, then the statement is true and you don't have a liable claim. But if in fact plaintiff is not infringing on defendant's patent, then plaintiff has a valid claim for liable. At least can prove this element of liable. So plaintiff says, look, to resolve my liable claim, we have to figure out whether or not the patent that the defendant holds is valid. And so that question is dispositive of the case. And as we all know, patent issues are resolved under federal law. So the plaintiff says, look, everything really turns on, does he hold a valid patent, which is a federal question. And so the court here is trying to decide whether or not 1331 would fit, and it tells us it doesn't. Justice Holmes writes this decision, basically says the test is, look to what law creates the cause of action itself. And if it's created by federal law, then you have jurisdiction. And if it's not created by federal law, if it's created by state law, then you don't have 1331 SMJ. So it's a pretty easy test. Look to the law that creates the cause of action. If it's federal, then you have a federal cause of action, or a federal question jurisdiction. If the cause of action is created by state law, then you don't have 1331 SMJ. All right, so basically, if you think about our initial question, which was, can a state law cause of action ever create federal question jurisdiction when there's some sort of federal issue involved in the case? Justice Holmes in American Works would say, no, it can't. It never can, because the cause of action, where it arises from, which law creates it, dictates whether or not it can come under 1331. And that was a pretty easy, straightforward test, and it didn't seem to make too many waves until all of a sudden we get Smith v. Kansas. All right, and in this case, shareholders sue under Missouri law in a shareholder derivative action, sue a corporation. And just to pause for a moment, essentially what a shareholder derivative action is the shareholders causing the corporation to sue the officers, saying that the officers have breached a fiduciary duty they owe to the corporation. If you think about it, officers control the entity, the corporation, and generally make decisions about who the corporation is going to sue or whether they're going to engage in litigation. Because the shareholders are arguing that the officers have offended their obligations to the corporation, the shareholder derivative action essentially lets them make an end run around the officers and force the corporation to sue the officers. So that's what you're looking at. Shareholder derivative suits are created by state law. All right, in this one, the shareholders were arguing that the officers were engaging in unlawful behavior or against their fiduciary obligations to the corporation because they had caused or were trying to cause the corporation to invest in federal bonds issued under the Federal Farm Loan Act, which they argued were unconstitutionally authorized. All right, so it's a complicated cause of action. If we go under the American Well Works test, the question really is, what type of cause of action is it? Is it a federal or cause of action either created explicitly or implicitly within the federal law, or is it a state cause of action? And the answer is it's state. So under American Well Works, the answer would be that there would be no jurisdiction. Right, plaintiff here is trying to say that there is federal question jurisdiction despite the holding in American Well Works. And the way they do this is they say, look, Missouri law said corporations cannot invest in illegal bonds, and because our corporation is being directed to do so, it was engaging in unlawful behavior. And that the bonds at issue that they said were illegal were themselves federal bonds. And they say that the reason that they were illegal, federal bonds, was that the Congress had unconstitutionally issued these according to the United States Constitution. So the key questions and dispute in this case were, are these federally created bonds illegal because they're unconstitutional according to the United States federal Constitution? A lot of federal stuff going on in here. Federal bonds, Congress's power itself, and constitutionality underneath the federal United States Constitution. And so for this one, the court says, well, This one you do. This one you do have federal question jurisdiction. And the tricky part is, why? Because it doesn't pass the American Well Works test. American Well Works says look to the cause of action. Is it state-created cause of action? Then you can't come in under 1331 jurisdiction. If it's a federal cause of action, then you can. If you look to the cause of action, it's created a Missouri law, so that fails American Well Works. So what is the court doing here? Well, in Smith, the court announced this test. It says, where it depends upon the plaintiff's claim or plaintiff's complaint that the right to relief depends upon the construction or application of federal law, we should be able to have access to the federal courts under 1331. Now, you can imagine that there's going to be some dissension on the court, and there was here, most notably by Justice Holmes. Who is he? Remember again, he's the person that issued the American Well Works test. And his big warning in this case was, look, don't monkey around with this basic, easy test to apply. Where does the cause of action arise from, or what law creates the cause of action? Because you're opening the door to get in a case like this, and you're basically opening Pandora's box. And we'll see in a little while when we talk about Grable in class whether you agree with Justice Holmes. All right. After Smith, we get more. In this case, the plaintiff sued his employer under the state employer's liability suit. In this case, it's a negligence claim. It's a state law claim. And basically, the plaintiff is trying to argue that the federal issue comes up in this case because the state law said that the plaintiff's contributory negligence could not bar the employee's recovery if the employer had violated a federal statute. So if you break apart the plaintiff's argument, here's how the federal question comes up. Plaintiff's contributory negligence was at issue in his case. Now, the state legislation said plaintiff's contributory negligence does not bar recovery. And remember, we're thinking about those old traditional contributory negligence paradigms where any contributory negligence was an automatic bar. Well, state legislation said it's not a bar to recovery if the employer himself had violated a safety statute. And in this case, the plaintiff was arguing, well, look, the safety statute you violated was a federal one, the Federal Safety Appliance Act. And so he argues that in order to resolve whether or not I'm even going to have a claim or have it totally barred under my contributory negligence, we're going to have to figure out first if the defendant had actually violated a federal statute. Now, you might wonder what the court comes up with here, given that Smith just told us that where it appears in the plaintiff's complaint that the right to relief depends upon the construction or application of federal law, we should be able to have a 1331 claim. But lo and behold, the court says there's no federal question jurisdiction. So, let's think about this. Does it pass American Well Works? The court's test where it says, does it arise out of the state law or arise out of the federal law, which creates the cause of action? It doesn't. Cause of action was not created by federal law. It was created by state law, so it doesn't work. So it should be like, no, the cause of action was not created by federal law. Does it pass Smith? Well, that's kind of interesting, because if you think about it, the right to relief here was dependent upon federal law. I mean, really, he wasn't going to have a claim if his contributory negligence was a bar, and it was only excused. It wasn't a bar if you could prove that the employer violated a safety statute. Here in this question, the only one at issue was a federal one. So we have this weirdo problem where you've got Moore that seems to totally directly conflict with Smith, and unfortunately the court in Moore doesn't seem to take account of that, and actually, in fact, cites Smith with favor, which is not helpful because it's not saying, hey, we overrule Smith. It's just saying, for some reason, these two things can stand together, and it's just, it didn't seem to. And for quite some time after Smith and Moore, the circuit courts were left in sort of disarray over this issue. So the Supreme Court in the 90s tried to resolve this through the case known as Merrell Dow, and this is the last, most recent attempted resolution coming up to Grable. So you're getting closer towards the case that we actually are going to talk about and spend most of our time on in class. Merrell Dow was a suit brought against a drug manufacturer for a drug that was caused birth defects to those who took it. And so it was a product liability case. This drug is bad, it causes birth defects, product liability. Now, in the product liability action, there was a claim based upon mislabeling, so a failure to warn, and it was argued that the drug was misbranded because there was no warning, and that was in violation of the FDCA, or the Federal Food, Drug, and Cosmetic Act. So you can see where the federal law starts coming in. Right, the claim itself is a state action, it's product liability. That's a first-year topic. That means the state. And the defendant who removed this to federal court is arguing that there's a federal question because the violation of the Federal Food, Drug, and Cosmetic Act is negligence per se. They're saying that basically that's how you prove your claim here in the negligence-based aspect of product liability. So the key issue is going to be, does a lack of a warning violate the federal law? And if so, it means that the defendant's negligent. So we have to basically answer that question. It's a key question in the case. The court here decides that there's no federal jurisdiction and said that they're going to resolve the conflict between Smith and Moore by saying that, look, we want the Smiths of the world. Is the federal bond that you've issued unconstitutional under the U.S. Constitution to come in, but not the Moore. Does your contributory negligence bar your claim because your employer violated a federal statute? Why? Well, they say, look, we look at the importance of the federal issue. And they say an issue is not important when the federal law does not imply a private right of action. And the interesting thing about it is this sort of sounds like we're almost close to American Well Works. We know that can't actually be true because Smith wasn't created by federal law. So we know it's important, but it doesn't really even fit the definition of what Merrell Dow concluded to be important. So while this was an attempted resolution of the dispute here, it actually didn't help. In many ways, it caused a lot more confusion. And so Grable is trying to justify all of these things. So when you read Grable, think about what cases the Supreme Court wants in and what cases the Supreme Court wants out. If you go back through our list, there's only one case that actually gets in under this crazy test, the state-created cause of action, in which is the federal issue in it, and that is Smith. So that's the key. Figure out what's different about Smith, and that's what Grable is trying to define for us. So just go now to Twen once you've listened to this and submit that you've watched this video. Submit a statement. There's an instruction there about how to do so that just says you've watched it, and bring your questions to class.